Having discussed the first problem type of question you can get, I'd like to discuss the second problem-based question you could encounter. Let's take, for example, the current situation of COVID-19, where the Minister Zuma has been given the authority to pass certain regulations pursuant to the Disaster Management Act. And part and parcel of those regulations is the banning of cigarettes and alcohol. And the regulations are duly passed, and you would know from legal interpretation that the definition of regulation per se is such that it falls within the constitutional definition of legislation. So to contextualize the problem, let's say some evidence comes to light that the reason why Nkosazana Zuma has decided to prohibit the banning of alcohol and cigarettes is because it's in her own personal interests, because she has a private company that sells such products, and for her own personal gain and interests, to the disadvantage of the greater South African populace. So that's your given set, and you are asked to, as a concerned citizen, what are your rights to address such situation. So in order to address the situation, you would need to consider, are you able to sue the minister, or are you able to address it by way of any form of application? So being a public law matter, your only remedy that is available is by means of judicial review. But you can only bring a judicial review application if you can show that the minister's conduct amounts to administrative action for purposes of PAJA. We know from the Barter Star case that your departure point has to be PAJA, the national legislation giving effect to subsection 1 of section 33. So you apply your Matau methodology. You say that the decision has been taken in terms of the promulgation of the regulation prohibiting the sale or being in possession of alcohol or cigarettes or tobacco. And the decision has been taken by someone who fulfills the definitional requirement of an organ of state, because the minister is not acting in her capacity as a natural person, and she's most certainly not a juristic person. So you apply the DAFI acronym, Department, Administration, Functionary, or Institution. She's a functionary in the sense that she's a member of the cabinet tasked with implementing these regulations. And the nature of the exercise of power in question is the passing of the regulation. You further ask, in terms of what has the regulation been passed? It's been passed in terms of the powers that have been invested in her in terms of the National Disaster Management Act. So the regulations have been passed not in terms of an empowering provision or a contract. It's passed in terms, it's given in terms of national legislation. And clearly it adversely affects the population. People are losing their minds because they cannot smoke or drink alcohol anymore. And it has a direct external legal effect in the sense that it impacts their rights individually, and it has a negative effect upon their rights. But it then leads to the question, does the exercise of power in question, is it hit by any of the exclusions in AA to II? And if you go through the list of exclusions, you'll see that the minister's conduct, the exercise of her power, the nature of the power and the nature of function in question does not fall within any of the exceptions. So when we apply section 1 of PAJA, we come to the conclusion that the exercise of the power in question, the passing of the regulations, and the nature of the power and the function in question constitutes administrative action. So that's your answer, that it is administrative action. Therefore, it falls within the definition of Section 1 of PAJA. Therefore, you can rely on PAJA to bring a judicial review application. Therefore, you fall squarely within PAJA. The grounds upon which your cause of action will be any one of the grounds in Section 6 of PAJA. And remember that you have to bring it within 180 days as specified in Section 7 of PAJA, and rely on one of the remedies as provided for in Section 8 of PAJA. Keep in mind that this is essentially an open book exam. You're going to have all your books available, all your source material, but don't fall into the trap of thinking that when answering a question, you can have this extensive period of time in order to consult your resources, because you only have 90 minutes. So it's all very well you have the material available, but be careful and be wise in the way in which you approach using that material. Use it only constructively. You have to have a core knowledge in order to answer these problems. So I hope I've made you understand or assisted your knowledge in the problem question which I've dealt with as to why it does constitute administrative action under PAJA and why it would be judicially reviewed in terms of the governing provisions of PAJA. Thank you.